Namaste. Welcome back to the week 7 of Conflict Management through Mediation course. In this week, we have already discussed with respect to other legislations which governs mediation in India or which supports mediation in India. Along with that, we also discussed with relation to the Singapore Convention on Mediation, and even we also discussed the mediation bill which is pending before the Parliament in India. In this today's session, we will be discussing on the online dispute resolution. So basically in this session, we will be discussing the basic concept of online dispute resolution, the legal recognition of online dispute resolution in India, along with some judicial precedents, and we will also discuss like the benefits of online dispute resolution. As we all know that in the present arena, everyone has the mobile, smartphones, laptops, desktops, and everyone has access to the internet. And as per the statistics, the global statistics, wherein we can witness that more than 2000 consumers are access to internet in Asia and stands at the top position at the global level. And with the development of information and communication tools has increased the access to internet, wherein the internet has brought all the people together on a single click, wherein the communication are taking place through mobile phones, that is through voice calls, chat messages, and even video conferencing. And how this information and communication tools, access to internet, the communication through these tools have helped us during the COVID-19 period. Like we all have witnessed, because of the COVID-19 period, everything was shut down and it was very difficult for a people to communicate, even to entertain and shopping. So there are various other facets of this information communication tools, but we are restricting only to this is because the communication is one of the important aspect for the access to justice as well. And this communication tools by means of online mode has helped the justice mechanism as well. So that is where the integration of technology has offered a crucial commodity to transfer information that can help the justice agency to make better and quicker decision. And we all have witnessed during the time of COVID-19, where the whole country was shut down and the Kerala High Court was the first to shut down. The court mechanism, the court procedure were totally shut down in Kerala for the first time during the COVID period. And they started hearing the matters of court proceedings in an online mode. So this is how the technology has helped the court system. And even so, this is how the online technology has helped the delivery of justice. And to understand the online dispute resolution, it is nothing but it is a use of technology to help the parties to resolve disputes in an online mode. It is basically, it can be the use of traditional ADR techniques like arbitration, negotiation, mediation in an online format, and resolving the dispute in an online mode. We call it as an online dispute resolution. Even the courts using the online dispute resolution by means of establishing various facets, and we all witness that what I was discussing, like video conferencing, hearing the matters to video conferencing, e-filing mechanism that has been developed in India, even in the present arena, in the year of 2020, the Supreme Court also gave an opportunity of hearing the matters, as all the courts in India are open courts, and even now the live streaming proceedings of the Supreme Court, High Courts are also been started, providing the opportunity of hearing all the matters before the Supreme Court and High Court sitting at your home, sitting at your office. This is how the technology has unevenly boomed and helping the delivery justice system at your doorstep itself. Online dispute resolution embodies mostly the communication capabilities that allows tasks to be performed more quickly or at a distance mode. See, the communication is helping. So the basic concept of online dispute resolution is that the communication that take place between the parties and between the third neutral party who is assisting the parties to reach at a settlement is that ODR is providing the communication tools, like it is only the use of communication tools in an online mode for the resolution of dispute. It is nothing but like it is a usage of information and communication tools to enable the parties to resolve their disputes. So that is where the information and communication tools is acting as a fourth pillar, as because whenever there is a dispute, there must be two necessity parties for that dispute, and for resolution of such dispute there is a neutral third party who will be acting as a third pillar, and the fourth pillar is like the information and communication tools who are assisting the parties and a neutral third party to communicate among themselves from a distance mode, that we call it as. So that is where the information and communication tools is very much useful for online dispute resolution. So what are the tools which can be helpful for communication? See, as already told, like we all are acquainted and we all are very much witnessed and well known about the communication tools that we use and we all use in our day-to-day life as well, like messaging, voice calls, emails, video conferencing, audio conferencing, chat boxes, and many more. So these are the communication tools which are helpful, and these communication tools can be divided into two types, that is synchronous and asynchronous. So the synchronous types of communication means it is an exchange of information between two or more people in a real time. So basically, to understand the synchronous communication, I would like to highlight with an example is like you call to one person and request to give something, wherein the other person who is hearing at the same instance, within a few seconds, he replies that whether he will be able to give or whether he may not be able to give. So this is like on a audio conferencing or a voice calls, the communication is happening, and the whatever the information which you want to give to the receiver, he receives at the same time and responds back to the same moment. So that type of communication we call it as synchronous communication. And the types of or the communication tools which are used in a synchronous communication is video conferencing, audio conferencing, and instant messaging. So video conferencing and audio conferencing are very much well related to this synchronous communication and even instant messaging, because the information which has been exchanged between such person on the video conferencing, audio conferencing, and instant messaging take place at the same moment, and even the opposite party responds to that within the seconds. So such type of communication we call it as asynchronous communication. Coming to the asynchronous communication, it is a type of communication where one person provides the information and then there will be a time lag before the recipients take the information and offers their response. So like emails. So whenever you email a person, so at what time he receives? Instantly he receives a message or an email, but he needs to open that email. He needs some time to open. He may be busy during that time, at the time when you have sent. So he will be opening some after some time, right? So once he receives that email, once he opens that email, so there will be a time lag between at the time when he receives the message and at the time when he opens the message. So this is where the time lag is. And since these types of communication, we call it as asynchronous communication because there is a time lag, and even he may respond at that moment itself or he may also wait to respond. So again there will be a time lag. So such time lag, whenever there is a time lag between the communication from one person to another person, so such type of communication we call it as asynchronous communication. And this synchronous communication and asynchronous communication has its own advantage in resolution of dispute. So we will discuss when we will be discussing the specific aspect of this course, that is when we are discussing the online mediation, how this asynchronous communication is helpful for online mediation and the synchronous communication is helpful. At what circumstances it is helpful, under what circumstances it is not helpful, we will discuss while discussing the specific aspect of this course, that is online mediation. Coming to the legality of ODR in India, see, the Constitution of India through Article 21 has guaranteed all the citizens the right to access to justice. Even Supreme Court has supported by means of Pushpa Sudan case, wherein in this case 4 principles of access to justice has been laid down, and that 4 principles are already been discussed in the previous sessions as well. But here, in order to elaborate the ODR, I would like to highlight 2 principles of this case which has been laid by Supreme Court, that is access to justice at an affordable price and access to justice at a nearby place. So these are the 2 examples or the 2 principles which are helpful for online dispute redressal, is because online dispute redressal provides a dispute resolution at an affordable price, because there is no requirement of a parties to meet at a single place, invest their time, invest their money for traveling, and they may be sitting at any place, anywhere, even at a different jurisdiction. It may be of different country. They may sit over there itself and discuss the matter and resolve. So there is no requirement of investing for a party for the traveling cost. Even more time will be invested, so that it need not required in an online mode of dispute resolution. Even it is where time saving and at a doorstep, because that is where the crux of online dispute resolution lies with. Even Article 39A of Indian Constitution impose a duty on a states to promote legal aid and provide at an equal opportunity, enhancing the access to justice. So these are the 2 main pillars, or what I can say is the grand norm for the establishment of online dispute resolution in India. Coming to the next aspect, that is Civil Procedure Code, wherein it is already been discussed with respect to Section 89, that the Section 89 empowers the state government to establish the alternative dispute resolution mechanism in the form of arbitration, conciliation, mediation, lok adalat, and order of the Civil Procedure Code lays down that the court may refer the matter to the alternative dispute resolution mechanisms. So This online dispute resolution mechanism can be adopted for arbitration as well, mediation as well, conciliation, lok adalat at any types, wherein even in case of arbitration, mediation, conciliation and lok adalat, where these are the types of alternative dispute resolutions, this type can also be performed through online dispute resolution mechanism, because in mediation, conciliation and lok adalat, it's a voluntary process. It is a party-centric process wherein the party themselves has to agree and come to before this alternative dispute resolution mechanism for resolution of dispute. And there will be the matter will be resolved through communication between the parties, and such communication can also be held through use of information and communication tools and resolve the dispute in an online mode. Coming to the Arbitration and Conciliation Act of 1996, the Act itself empowers the parties to choose the place where the hearing would like to take place. And even in case of arbitration or in case of conciliation, the parties have a discretionary power to choose their place. That means they may also choose the place where they are residing and discuss the matter through online mode and hear the matter and settle that. And for the purpose of this, there is a requirement of certain sanctity which has been provided by means of Information Technology Act of 2000. Like, by means wherein says there, I would like to highlight this Information Technology Act with the use of one example. Say for example, an alternative dispute redressal mechanism is being used in an online mode and the matter is being settled. Either it may be arbitration, through mediation, through conciliation. The matter is being settled and the agreement is being reached. And now the parties is required to enter into an agreement. So under that circumstances, the parties sitting at a long distance who discussed and settled their matter by means of arbitration, conciliation and mediation through video conferencing mode, and they want to enter into an agreement. So for electronic agreement, there has to be certain sanctity and that sanctity is been provided by means of Information Technology Act, wherein Section 4, Section 5 and 10A provides the legal recognition for electronic records, signatures and validity of electronic contracts respectively. So Section 4 talks about electronic records, Section 5 talks about electronic signature and Section 10A talks about electronic contracts. So that means, so electronic records are well recognized, electronic signature to any agreements is well recognized under Section 5 and Section 10A validates such electronic contracts. So this is how the crux of ODR lies with the Information Technology Act. Even the Indian Evidence Act recognizes the electronic records, whereas electronic records are also admissible in court of law, which is derived under Section 65A and 65B of Indian Evidence Act of 1872. Even now, the video conferencing, e-filing are been well recognized under the Consumer Protection Act of 2019, wherein the courts can hear the proceedings in a video conferencing mode, and why not the alternative dispute redressal mechanisms. So even the courts, annexed mediation centers, the arbitration wherein the court has referred such matter to arbitration proceedings, that can also be heard through online mode and resolve the disputes. Not only the legal sanctity, but even the judiciary has also played a vital role in recognizing the principles of mediation. So principles of online dispute resolution. The case of Shafi Muhammad vs. State of Himachal Pradesh. This is a case of 2018 wherein the Supreme Court held that electronic evidence is a valid subject to safeguard and adopted by the court for verifying the authenticity of the same. But it further went on to say that the standard of proof of authenticity and accuracy has to be higher than the standard required for documentary evidence. So that is like the electronic evidences are well recognized. So that means the parties can produce electronic evidences before the court of law, even before the adjudication process, through arbitration, or it may also produce evidence before the conciliation proceedings, Lok Adalat proceedings, wherever necessary. So that means electronic evidences are well recognized under the court of law as well. And in case of Thomso Brono versus State of Uttar Pradesh, this is a case of 2015 wherein the electronic evidences is admissible and held that Section 65A and 65B of Indian Evidence Act are only concerned with the procedural requirement as to how to produce such documents, and the court held the electronic evidence are well admissible. In case of State of Maharashtra versus Praful Desai, this is a case of 2003 wherein video conferencing is been validated, and even the court went on to held that it can record the witness statements in an video conferencing mode. Grid Corporation of Orissa Limited versus AES Corporation. This is a case of 2002 wherein Supreme Court held that unless the law or the contract between the parties requires physical presence of the other party for consultation with one another, the electronic media and remote conferencing are held as valid. So unless any contract or unless any court of law which mandates the party to have a physical presence for witnessing the statement or producing the documents, unless the law requires such mandate, so it can be held in an online mode, and that online mode or a remote conferencing are being held valid in this case. So there are very best examples wherein the arbitration proceedings were being conducted in an online mode. These are the two cases, that is Shakti Bhog Foods Limited versus Kola Shipping Limited, a case of 2009, and Trimax International FZD Limited versus Vedanta Aluminum Limited, a case of 2010, wherein the parties have decided upon arbitration through emails. So these are the two best examples in India for recognizing the online dispute resolution. Now, it is well developed that the online dispute resolution is well recognized because of these cases, even if these are statutorily recognized. But unless and until there are certain benefits of the online mediation, we won't adopt it, right? And let us discuss about the benefits of mediation and why we should adopt the online dispute resolution. Some of them we are already discussed, like it is speedy, it is affordable. But let us discuss in depth with respect to what are the benefits of online dispute redressal mechanism. See, when we speak about the online dispute resolution wherein the communication takes place in an online mode, it itself denotes that the scope of online mediation is not only restricted to Indian jurisdiction, but it is globally applicable. If there are any cross-border disputes, a person sitting in US and a person sitting in India having dispute, or that can also be resolved in an online mode, and it did not require the person who is sitting in US to come to India, wherein it takes place in case of the normal court proceedings. It takes place in a normal arbitration and physical mediation, physical conciliation and physical Lok Adalat proceedings, wherein the presence of parties must in physical mode, whereas in online mode, there is no requirement of a party to travel. So that is where the crux or the important benefit of online dispute resolution lies with. And because of that, it is speedy, it is qualitative, it is cost effective. It's because PD is because there is no party, because the party sitting over there, he need not require to travel, he need not require to be free to travel from US to India, he need not require to apply for visas, and that is where it becomes speedy. Even when we talk about the speedy justice, even if a party who is laying in a hospital, he need not require to recover from the diseases which he is suffering. If he is admitted in a hospital, from there itself with the permission of a doctor, if he is capable to do so, he can present the case, he can discuss the case and resolve the dispute over from there itself. And this is where the cost effective as well, because there is no requirement, it is very cost saving. So this is how the online dispute resolution is cost effective, speedy, and it's qualitative. Coming to the synchronous and asynchronous mechanism to which I was talking earlier with respect to the communication. The physical communication which take place at resolution of dispute, like the verbal communication, the non-verbal communication, the basic concept of that are already been discussed in the previous sessions in depth, and the benefit of that verbal and non-verbal communication are already been discussed. Whereas in coming to the online dispute resolution, the communication takes in a virtual world, that is through video conferencing, through audio conferencing. And here, most of the times, we in an online dispute resolution, we conduct a verbal communication, that is a language communication. And sometimes, in case of online dispute resolution, it can be a text-based communication as well. And whenever there is a text-based communication, there exists the asynchronous type of communication. So asynchronous type of communication like that means that will be a time lag. And whenever there is a time lag and a neutral third party who is assisting or who is looking after the text-based communication, under that circumstances, the importance of asynchronous communication lies over here, wherein if there are any wrong or any adverse communication that has been made by other party, the neutral third party may rephrase it, may paraphrase it and put it to the other party. And the importance of paraphrasing, the importance of rephrasing are already been discussed in the previous session, so I don't want to repeat it out. But for the sake of this discussion, I would like to highlight that if in case the rephrasing and the paraphrasing will be done by the neutral third party and communicate to the other party, so the chance of resolution of dispute will increase. And this is how the asynchronous type of communication has its own benefit in resolution of dispute in an online mode. So that is where think before communication, that is we think before we communicate. When it is a text-based communication, even we think before when we communicate in an online mode. When the parties are sitting in a physical mode, there might be certain existence of angry emotions which may come up, and there might be certain circumstances wherein the deadlock can be established. So that is where this online dispute resolution brings down the deadlock mechanism and it provides for an effective resolution of dispute. With this, I would like to stop over here and thank you for your patience hearing. Thank you.